Good morning, everybody. Good morning to the participants of this webinar. That is the last one of the final conference for JSAFE project. We are at the end. On the 14th, the project expires, and so we are I would say, celebrating the last part of this project. We will go about the harmonized guidelines for judges. The guidelines aims to provide judges who deal with the issues of radicalization support in making informed decisions on sentences related to radicalization. The guideline also provides notes, information for including on individual resocialization and rehabilitation plans for inmates who are under the observation for radical behavior. The handbook is divided into 3 parts. Analysis of the terrorism radicalization nexus. The second part deals with the analysis of the reverse the nexus justice radicalization, and the third part is a proposal of 10 policy recommendations. We had the contribution of important people to these guidelines. First of all, Dr. Turini Vita, who is the General Director of Training Directorate of the Italian Ministry of Justice, who wrote the foreword of the guidelines. Then we have the introduction written by Dr. Bianchi, our security practitioner and editor of the guidelines. Then we have the preface wrote by Dr. Spadaro. He is the chairman of the Juvenile Regional Court, first in Bologna and now in Trento, up in the north of Italy. And at last, but not least, we have Dr. D'Ambroso, who wrote the conclusions. He is the prosecutor office in the court of Bologna. At this point, I will give the floor to Dr. Franz, who is the assistant to the national member for the Italy Eurojustice, who will be the moderator of this webinar. Please, Dr. Franz, you have the floor. Please turn on the microphone. I can't hear.
Hello?
Yes. Oh, okay.
Do you hear me?
Hello?
Yes, I do.
Okay, thank you. Thank you for everybody. It's a pleasure and an honor to moderate this webinar whose speakers are distinguished colleagues as Mr. D'Ambroso, a friend,
Hi.
and Mr. Ferrand, and Professor Antinopoulos as well. To be informed about the subject, I have read the Harmonized Guidelines for the judges, and I would say that the issue is quite challenging. Just a few words to introduce me. I am a prosecutor. I have been appointed to Eurojust, the agency for the cooperation of the EU, judicial cooperation of EU. But for the first 30 years of my career, I have been the prosecutor in different places and in charge of terrorism cases. Last part of my career during the last 15 years. Well, let me introduce just in my experience during when I was appointed to the anti-terrorism unit in Italy. Just reading the book, the handbook, I remember a case. It was quite particular. A national young man. His family was a middle-class family, good education, and he converted to the Islam, and he started to attend the mosque in Genoa. And that's what it was the time when the police was started to monitor his behavior. And at the beginning, it was just a new converter, but day by day, step by step, he started to quarrel with the others members of the community, considering them too moderate. And then with the police, we opened the case and we started to monitor the process of radicalization of this person, of this young man. All the West society was evil, and progressively he started to cut the links with the family, with the old friends, and thinking about the possibility to be a martyr. Using the technical devices, we progressively monitored all this process in his mind and in the relation with the other members of the small group he had created to focus is willing to fight for the Islam. And at the end, he decided to go to Syria. He tried once, and the second time he succeeded, and he entered a foreign brigade whose chief was a Chechenian. During this experience, he sometimes called his family, and at the end, his father received a phone call by the chief of the brigade telling him that his son was dead. The family received only his diary, but his body disappeared. So this is my experience. The experience of, and I wanted to share it with you, just to say that every case is different from the other. I have met different foreign fighters, and in this case, for instance, he was not at the margin of the society. He was integrated, was a member of the society. He has had a middle class. He was member of a middle class family, good education, as I said. But something happened in his mind that and he passed from the conversion to Islam to the radicalization, and afterwards, at the end, to decide to be a martyr, to fight, to be a foreign fighter in Syria to support the Islam State. I don't want to steal other time to the speakers. I wanted only to provide my experience as a public prosecutor in Italy. I think that we can start, as it's written in the agenda, with the colleague D'Ambroso. Is it possible? Or
yeah,
yes.
I hear and I'm able to speak, but unfortunately, I have not any image of the webinar. But if it's possible, I can speak and I can talk.
Well, just to quote a famous movie, Mr. D'Ambroso will speak about the thin red line between terrorism and radicalization. The floor is yours.
Hello? Oh, perfect. Okay. Thank you very much for the invitation, and thank you, Mr. Franz, for your moderation. I'm very proud that an Italian representative of our magistration institution is in a very important office that organize and coordinate the activity of terrorism. So thank you everybody. And I will talk about not only of personal experience, because I consider the experience of Mr. Franz one very important example of the Italian experience of counterterrorism. And I would speak of a specific area, of the important book that we are analyzing this morning. And it's very important to underline, to stress the consequence, the results of the counterterrorism legislation after the directive, the EU directive 541 2017, after the tremendous attacks in France and in Central Europe, when all the nations was concretely convinced to introduce in their legislation new law which anticipate the counter-terrorism activity of intelligence police and the judiciary orders. I would like to say that after the 2017, we have all the 27 nations in Europe a very good coordination legislation, more than enough to counter terrorism since the beginning of since the starting activity of their terrorism aim. But the point that is very important to stress in a webinar like this is that we, as experts of the team, we have to underline, we have to determine what is exactly preparatory act, what is an anticipation of a terrorism attack, and separate this kind of analysis from another part of a real problem, which is the radicalization. Because we have to be very aware that since 2012, so before 2017, so it's more or less 10 years ago, the EU a lot of money for citizen taxes for very important project and program to study and to analyze and to prevent the radicalization, which is a preparatory area, which is a part of the problem that we must continue to consider very separate from the crimes, from the criminalization of a single attack. I want to say that radicalization is a problem which is not necessarily associated with Islamic activity of terrorism, and radicalization is a problem that we have. We must, with our total energy, to treat and to counter since the beginning of it. For example, in detention area, in prison, where we found a lot of radicalized people that entry in prison not radicalized, but they get radical staying in prison, and this is a very important problem on whom we have to work. We have to work day by day, because it's very important not consider the radical presumptive man associated in a terrorism area, but we have to consider him a man which is in a very difficult situation of his life, that is ready to become a criminal, maybe a terrorist, but we have to work in terms of education and in terms of prevention, and not isolate them in specific part of prison where they are left without any other attention and without any specific program of education. So I think that it's important to remember and remind ourselves always that radicalization, it's not the same thing, it's not the same situation of terrorism, and we have to counter terrorism without thinking that it's the same problem of radicalization. So we are studying a lot in each of the 27 countries, with a lot of EU financing program to counter radicalization, and I'm very optimistic that in the few next year we will find a common program of counter radicalization, which will be enabled, which will be enforced in each country of Europe. So I think that the importance of this part of book that is very interesting analysis that show us a very interesting analysis of the interior problem of terrorism is in the part where we have to distinguish the area between terrorism and radicalization. So I would thank all of the colleagues that is listening my confused, unfortunately, without imaging contribution, but for me was very important to be among other European colleagues and to give my contribution, stressing this very important point of the book. Thank you, Mr. Zart, and thank you everybody for listening to my contribution.
Thank you, Mr. D'Ambroso. If I may ask you a clarification, if I have understood correctly, you considered the concentration of terrorists in the penitentiary system not correct.
Exactly. It's not correct. It's not correct, and it's not correct to leave them in isolate part of detention building where they are considered special criminal area. So we have to work a lot on them. The specific program financing by the European Commission that is working a lot since 2012 on this specific area, counter-radicalization.
As you know, the decision in some EU countries to concentrate the terrorists in special units is justified by the fact that radicalization is a kind of virus that can be spread to the other detainees, and so that's what's the reason why the concentration of the terrorists in special unit preserve the other form, the danger of the radicalization. What do you think about it?
No, I think that it could be a good option to move the situation that at the moment we have in the organization of detention live in the penitentiary building in Italy. So for me, it's very important sharing your point of view that we have to work.
We have lost. We have lost Mr. D'Ambroso. Perhaps it's better to go forward, and possibly we will come back to Mr. D'Ambroso at the end of the webinar. And well, I am very interested in the next presentation by Professor Antinopoulos. She will speak about restorative justice, and I am eager, because I am a bit ignorant, to know something more about restorative justice, if it's applicable to terrorism crimes, and what are the specific features of the restorative justice applied to this kind of crime. Professor Antinopoulos, the floor is yours.
Thank you, and thank you for the main question on the issue. So I would like to thank the organizers for the invitation to join you today. I think that the whole issue of radicalization and especially the project, the JSAFE project, and the handbook produced by the project are really very, very useful. So actually, as Mr. Franz, the moderator, already put the question. This is the main question, but let me start about exploring the concept of restorative justice, exploring the practices of restorative justice, and then we focus on radicalization. If I may, I would like to share a presentation with you because sometimes there are technical problems in this kind of conference. So if you have the image, if you have the slide, maybe it's easier for the audience to follow. I will start my presentation exploring what restorative justice is, and then I will focus on the JSAFE contribution on the handbook. Then I will pass on the experience we have from penal mediation in Greece, and I will end with some warnings and dilemmas on restorative justice. So the concept of restorative justice is really very, very complex. There are many definitions. However, there are some key words. I have defined restorative justice as a different zeitgeist, a different perspective, a different paradigm. Because restorative justice has adopted different concepts and definitions on crime and violation. The key concept is the offender's accountability, the victim's needs, and the restoration, the healing, and reintegration of the community. The community involvement is a key issue for restorative justice. And of course, in this paradigm, the philosophical background are on the values of justice or the justice as a value. And of course, it's mainly a bottom-up perspective. I have argued in my publications that Aristotle was the father of restorative justice because in the holistic theory of justice of Aristotle, as cited in the Nicomachean Ethics in the book 5, Aristotle states the restorative law. And the restorative law includes the concepts of equity, includes the citizens' participation in the involvement of the community in the courts, the communication between the two opposite parties and trying to find a solution. So that's why I suggest to say that in the references that Aristotle was the father, it's not so new concept. But one question is why today we're speaking on restorative justice. And I think that the one key point was the terrorist attack in New York in September 2001. Because afterwards, after this attack, we have a shift in the paradigm of the criminal justice system and the responses to the crime. Of course, there are other key points in this way to restorative justice, such as the crisis of the criminology, the high rates of reoffending, the zero tolerance policy, and the punitive attitudes we face today. So let me say that the deadlocks of the criminal justice system demand different ways of responding to the crime problems. Just one slide on penal populism, because we face penal populism in Europe, in many parts of Europe and US today. And it is reflected in the punitive attitudes. We have plenty of research on that. Though the crime statistics in Europe declined during the last 10 years. So there is a controversial issue here. We have an increase in the penal attitude, but a decrease in the statistics. So restorative justice comes to restore the mistrust of citizens in the criminal justice systems and the rule of law. Restorative justice includes a value-based perspective that involves the community, citizens, and policymakers in an open-ended dialogue. The main restorative justice practices are the victim-offender mediation or reconciliation, the community conferences, and the restorative circle. These practices are not so European originally, but Europe, because of the legislation and the many recommendations we have from the Council of Europe, from the European Commission, from the European Union, we have to implement restorative justice. So this is a challenge on how to implement these restorative justice practices. The fields of implementation of restorative justice could be the criminal justice systems, and here I mean the diversion procedures, the prison settings, the field of juvenile delinquency, some social phenomena such as school bullying and proactive intervention to the non-violent strategies, restorative justice in the community, and it's a model of civil mediation, restorative justice in the families and in the workplaces. However, the main question is where restorative justice really works. What evidence do we have until now? I mean, research, impact assessment research, evaluation research, and testimonies. So we know that restorative justice is appropriate in property offenses, in the field of juvenile delinquency, in reducing recidivism and keeping the distance from the crime. But there are open issues, such as the use of restorative justice in the domestic violence, in homicide, in sexual offenses, and of course in terrorism and radicalization. We don't have strong evidence on this. Especially on radicalization or radicalization, we are aware that the practices of reconciliation embrace both individual process like forgiveness, apologies, but also and group-related societal development like forming and transforming a collective memory. We have plenty of research and references on transitional justice, the aims of transitional justice that aim at social healing for overcoming a vicious cycle of terrorist violence and counter-terrorism measures. The restorative justice practices as dialogue, narratives, victim statements, implement at conflict resolution resistance, and they could implement in a de-radicalization strategy. The offender social rehabilitation and social inclusion work more effectively through the alternative sanction and the community involvement. And in this perspective, restorative justice practices could implement both at the proactive and the aftermath level. In this context, I found the JSAFE project and the publication, the handbook, very useful. The handbook comes to advance the restorative justice dialogue and suggest certain guidelines and tools for judges through providing experimental models of RJ in cases of radicalization and new forms of virtual terrorism, through promoting the public-private collaboration and community integration through the involvement of the civil society. The handbook also addresses cultural mediation measures in preventing context and in proactive perspective, and also suggests a module of community impact assessment for helping record, monitoring, and take appropriate action in the relation to community tensions. I love this last part, impact assessment tools. I think that they are very, very useful because we have an idea of what we're planning and what we implement at the end of the day. So the publication of the handbook, from my point of view, is inclusive and holistic because it has a gender and child-sensitive perspective. Very well documented, it's practical. It is a useful tool for the researchers, for the professionals, for policymakers and stakeholders, not only for the judges. It is adaptable to other settings. And of course, it's challenging for the critical issues in theory, research, and practice in the field of radicalization. In this part, I will share with you our experience from Greece on victim offender mediation. And I will start with an agreement that we have signed between three parties for last years now, for 4 years now. The parties are the Restorative Justice Lab. It is an institute that I found and directed in Pantheon University of Athens. The other part is the Greek National Authority on Training of Public Administration and the Greek Association of Probation Officers for Juveniles. This agreement, this memorandum of understanding, was not a theoretical one, but very practical, because we aimed at strengthening the interinstitutional collaboration and to bridge the gaps between theory, research, practice, and policy making in the field of restorative justice and penal mediation. We aim at implementing tailor-made training activities for the probation officers and other professionals in the criminal justice system. Of course, to develop training material and of course to assess the impact. So until today, we trained all probation officers of the country in trainings organized in Athens and in Thessaloniki, and we focused on real and difficult cases of juveniles delinquency. We also trained 20 prosecutors and judges of the juvenile courts of the country in restorative justice and victim offender mediation, focused on the young offenders. And the Restorative Justice Lab has a twofold role. It has the supervision and the implementation of victim offender mediation, and of course it has an advisory role to the professionals for further guidelines. What was the impact? The institutional impact of those activities was the publication of a circular by the General Prosecutor of the state to all prosecutors and judges of the country on how to implement restorative justice and reconciliation in the field of juvenile delinquency in all stages of the criminal proceedings. So it is a step-by-step guide to all judges of the country. Of course, there is other experience in the field of restorative justice. And in this last part, I'd like to share with you my warnings, my dilemmas on restorative justice, because restorative justice is not one recipe for everything, but it has some limits and so some warnings. So the first warning is about the potential individualization of crime, because defining crime as a conflict between the parties, you may lose the wider social, cultural context. So there is need to protect the public character of the crime as violation of human rights and not just a mere conflict between the parties. The second warning is about the privatization of doing justice. We may see a shift from the public to private policies. And maybe restorative justice could be an outsourcing criminal justice policy. This is a danger. And of course, the legitimate power of the state to handle crime and criminality issues may shift to the social actors. So there is a warning on the possible violation of human rights. And the main problem is that the evidence and the research on restorative justice is still too weak. The third warning is the cost-effectiveness approach and the politics of restorative justice. Let me say, doing cheap justice is not a very good term, but it is a real term. In the era of austerity, maybe would be an alibi for the politicians, and the cost-effectiveness studies on restorative justice we have until now do not usually include a social capital approach and a proactive impact assessment. So we stay only in strictly in numbers and in costs. And I think that crime is, as a phenomenon, is more complex than this. And the last warning is the potential widening of the social control, because restorative justice practices sometimes may reproduce the power structures and the attitudes in labeling and stigmatizing the offenders and in the victim's safety, including the risk of secondary victimization. So restorative justice as theory, research, and practice comes to bridge the gap between the principles and the values of justice and the realities in the traditional criminal justice systems. Restorative justice comes to restore the mistrust of the European citizens in the criminal justice systems. There is still a long way to evidence-based knowledge in what field restorative justice really works and what is the impact of restorative justice practices in the individuals, the communities, and the society. The JSAFE guidelines to the judges in cases of radicalization are extremely useful, practical, and operational. It is an added value to the good implementation of the penal mediation. And last but not least, any warnings and dilemmas come from the need to protect the values of justice, the human rights, democracy, and the rule of law in this strange era we live, in the era of austerity, risk, and insecurity, and the era of pandemic, of course. So thank you very much for your attention.
Thanks a lot, Professor Artinopoulos. Extremely interesting and useful your presentation. And well, I was thinking about yes, the application to restorative justice in cases where, for instance, occurred in Paris, terrorism, slaughter in Paris and in other places, how it could work. Yeah. And yes, I would say perhaps specific, yes, here the community is quite important, the approach of the project to well, this phenomenon by all the community, not only by the specific victims of the crime, well, as you said, till now the experiences are focused especially to the juvenile criminal phenomenon, or the some kind of crimes committed inside the family or whatever. But well, terrorism is a great challenge, I think, also for the restorative justice.
Exactly. Under certain conditions and in certain context, we can plan these activities because the dialogue is always very, very useful.
Thanks a lot. Thanks a lot, indeed. Well, let's pass to the third presentation, and the speaker is Luc Ferrand, legal advisor at the European Project Foundation, and previously, as I understood correctly, he is an experienced judge. And I want just to start with a provocative question. The prevention is a problem for judiciary or not? Because, well, the floor is yours.
So thank you very much for your kind words, and of course for asking me to join you this morning. I'm really honored, and I'm very pleased, and I have been hugely challenged by the ones talking before. As you ask me this strong question about prevention, I would like to start with some little feedback to tell you that in my own experience, I had to think twice to these kind of questions. First of all, 10 years ago, when I was in charge of the Counter-Discrimination Authority for France, and a few months ago when I was presiding the Judicial Committee for French language, in charge to advise the French Academy about the concept of radicalization and de-radicalization. And of course, we can resume radicalization and de-radicalization in a few words only, but the question of where it comes from and then when the way to prevent it is, on my own opinion, a very, very huge question, as well the question of restoration of links and dialogue, as it has been already pointed out, especially regarding the question of restorative justice. So when you ask me to challenge your own proposal, I said you when preparing this meeting that to me, to my point of view, especially regarding the lacks and of course the failures in some member states and especially mine, I do think that the handbook is of very high value, because it goes to very concrete proposals, and to me it brings concrete answers to many challenges we are daily facing. And I would like to emphasize during my own work, during my own time and with my own words, the real need we have to take your proposals into real and concrete consideration. To prepare this speech, I try to stress out four main ways to focus what are the daily problems. So to aggregate your proposals as some subgroups and make sure that I can create links between failures and proposals. My first focus will deal with social ties and links, especially education and way of life. I won't be too long, of course, but what I've been able to observe is some sort of segregation within the territories at national level. And we can see that in many Western countries, the less wealthy are today banned from the city centers to the suburbs. Also that, especially because of budget cuts, social policies are weaker and weaker. And we all know that, especially religious associations, as they already made in the Middle East, they do act today as main suppliers trying to help families in distress. We have been able to observe that, especially during the first phase of the COVID crisis last spring. And they also bring support to children when they are in schools difficulties. This has been the way the Muslim Brotherhood worked, especially in Egypt. And they are nowadays, especially in France, reproducing this behavior and then in some way invading the wide spaces unoccupied by state. And it is very interesting to point out that today the priority of the French government is to keep schools open, and the president said, at all costs. And that the new law in preparation and submitted to Parliament is trying to forbid any kind of education out of school, and especially out of school which are not financed and supported by state itself. So I think this is really a strong and huge question. And I can testify that when I was in charge of the counter-discrimination authority, French authority, I was myself challenged. You know, school is not only to teach you the fundamentals, not only mathematics, French language, English language, and so on, but also culture, open mind, and especially to art and, for example, music, architecture, and so on. And we were challenged by groups asking for children not going to visit cathedrals because they were not Catholics. And even at nurseries for children between 1 and 3, groups or associations ask us to ban the 3 Little Pigs story. I suppose you all know the 3 Little Pigs. They do build their own house, and the big wolf is coming to eat them. But because pigs were present in that story, associations ask us to ban the book out of school. So I can really say that we are facing 2 different worlds, living segregated. They don't mix anymore. There are some kind of invisible wall between these communities, Western, like, and wealthy one side, and the rest of the world living on the same territory, but out of space in some way to say. And the lack of mediation and conciliation and dialogue cannot be even evoked nowadays. So this is really the background I had to face in my own career. So from the handbook, I can see really strong ways to go ahead, especially with that idea that we have to restore the dialogue. And I wanted to emphasize a few examples that have been used by the past and which are now maybe coming back. We had developed before in France, especially, the concept of proximity police and funding association, which were called Elder Brothers. Elder Brothers are successful young people from the communities, and they are supported by state or by the cities to challenge the one in difficulties to rise up and to go ahead. The proximity police is not police to control, but police to serve. Regarding the definition of what is the police, to protect and to serve. So this is another way to consider the relationship between police and people. Today is a very special day in France, and I think it's a good example because these two previous policies had suffered a lot of budget cuts. But today, really starting today, the French police decided to be on Snapchat. First of all, I was very questioned by that idea. Why? What for? And I tried to think about it, and I think that the concept of accessibility, the concept of having a social network in common, can be as well very interesting to restore some kind of common language. And I have to say as well too, that during the preparation of this speech this morning, I had to talk again with police forces and colleagues, and they pointed out the huge work made by the Ministry for Education as well by the Ministry of Internal Affairs to develop programs at each level to encourage especially the associations and the cities to build policies really in I would say that in harmony with the proposals the handbook develops. So I'm trying now in the second part of my speech to put better in relation these initiatives with the handbook's initiatives. I think one of other strong difficulty we have to face is the maybe failure in the self-confidence of state itself. This is especially developed in French political vocabulary, that we are not able to face the challenge. And we are used to point out our own difficulties without facing the opportunities we can take. So I've seen and appreciated a lot that the handbook was skirting the S5 policy, the French S5 policies. So the people under watch or more or less control, and the fact 20,000 people are more or less under control, and that too many people under control probably means no control at all. So there as well, I think, something to reinvent, and especially appreciated the suggestion to define something in common, something that could be at EU level. And regarding what has been done by the EU for probation, which was, I think, something really new, probably imported from Canada, but we have a lot to learn from our cousins of Canada. I think that restorative justice instruments could be very useful to be developed all around Europe, because of course we cannot consider that each member state can stay isolated and develop its own policy regarding so strong questions. So I think that self-depreciation for national authorities should be balanced, as suggested by the handbook, by stronger European policies. Regarding the question of repression, but there I have to go fast because it has been widely developed before. I think the meaning of punishment, and this will enforce the idea of restorative justice, has been probably completely lost by the radicalized people, because usually prison is there considered as some sort of enablement. And we are facing also strong difficulties during the period when these people are imprisoned, because we are not able to deal even with spaces in jail. What I had to face was or segregation during incarceration with dedicated quarters to radicalized people, or when the author of the attempt is considered as highly dangerous, very strongly dangerous. I especially there refer to Salah Abdeslam case. The idea was to bring the guy under constant surveillance. He was filmed 24 hours a day with a complete lack of privacy. And of course, this leads to complete violation of human rights. Then there is no room when considering jail like this, of course, to prepare social reinsertion. And this is another value, strong value from the handbook, that the time of imprisonment cannot be a stronger segregation than normal life, but it must be useful period. So what are we working on nowadays? We are working on a new policy to enforce alternative sanctions or penalties, enforcing again probation, and enforcing more and more services, concrete services to community as a penalty to reincorporate the people in the community. This is probably strongly coordinated and must be put in strong relation with the concept of mediation on one side and restorative justice on the other side. But of course, it costs a lot, especially in that period of disease crisis and then economic crisis, to take time to have an adapted way for each case. And of course, when you are in a lack of work, defining what can be the adapted and appropriate job for the one to reincorporate or to reinsert within the community is, of course, much more difficult than during a wealthy period. So my colleagues told me that when we are now ready to break free with the first generation of terrorists who are going to leave jail during 2021, nothing has been properly prepared, and the only reference is one meeting a week with a probation officer, which of course is obviously completely insufficient. And of course, the government had different willings, but it was before always in a repressive way of thinking. It was the idea of reincarceration by changing the legal basis. You have been punished, your term is over, but you are still dangerous, so we keep you in jail. It was, of course, completely excluded by the Constitutional Court, and then the law was cancelled. The second idea was to monitor these people under or by electronic tagging, but here again, last year, it was excluded by Constitutional Court. So this is clear to me that without taking into consideration pragmatic proposals like you did, working on prevention, working on restoring the dialogue, working on the term itself and the conditions of the term, working on the way to reinserate people. It means regarding closely each proposal you made, we are not able to face the challenges, the nowadays challenges. And my worry is that really, if there is not a common policy, especially within the EU, we could be in the position that we have been facing before in Western Europe. I mean, trying to define what could be a counter-reform or a counter-revolution. And you know how difficult it is when you start on that sort of a basis. So this is the reason, to make a short conclusion, what I think we do need your experience, you the authors, your analysis, your proposals as guidelines. Thank you very much.
Thanks a lot, Mr. Ferrand. It was a clear panorama of the situation, the difficult situation where we have to work and tackle the problems for all the reasons that you mentioned. There is a question we received for all the speakers, and I read it. Consider the historical period we are living in with this pandemic, COVID-19, that restrains the human contact. How does the observation of radicalized people change, if it changes? And secondly, may this change be applied to restorative justice?
I can just repeat on my side what I already said about school. During the first lockdown in France, all the children were sent back home, and then they were completely cut off, out of the public area, and with absolutely no links with their own teachers and with their own friends. And then, especially radicalized organization invaded that new free space. So to me, there is that sort of impact. And as well, for the courts, they were only dealing with judging and sentencing, but not anymore with support and preparation to reinsertion. So because we were facing lockdown for the very first time, the ministry decided to make some cuts to protect people. but for more or less 3 months, there was no more active policy to help and serve.
Professor Antinopoulos?
Yes, thank you. It's a really interesting question, and I think it reflects everybody concerns about the pandemic we live. And I can't say for sure what the effects could be on restorative justice or in the community level, because we can't assess, we can't estimate the effects of the pandemic in the societal level and in the individual at the moment. However, I could say that it seems a bit strange right now to think and to discuss on restorative justice if we face the big danger on the public health. And this is a kind of trap. I mean, because it's a pseudo dilemma. We have our lives, we have our priorities, but we have to consider how, through this crisis due to pandemic, the communities and the individuals would be strengthened in their demands, in their needs. So for example, some restorative justice practices like mediation could be facilitated through Skype, through other, platforms. Yeah, and maybe that would be safer for the victims, and maybe some have positive effects on the process itself and the parts. But my concern is that the values, the human values we have, the values of justice, everything in this value level is challenging by the pandemic. And I can't say if these challenges will be positive or negative, or I don't know. The issue is very, very complex indeed, and then they can't say nothing on this. But we have to try and we have to adjust in this context. For example, the good practice in the Greek police during the pandemic on domestic violence was that the ministry asked for a research in the general public about the domestic violence, how the victims experience restorative justice during the quarantine. And I was really honored to take over this research. And what we see from our sample is that some types of domestic violence were reduced during the quarantine. But the types and the forms, the kinds of domestic violence that, of course, pre-existed, it's not something new, that pre-existed, were sometimes were more severe in the effects of the victims. So what I'm trying to say is that we need more research, we need to share our experience, we need to talk about them, and then we try to find best ways, best strategies on how to deal with what happens in our lives.
Thanks a lot. There is another question for you. Can you please explain more in detail the term of penal populism and how this is affecting our society?
Yes, very challenging. It's a wide term, penal populism. It is a term that describes the attitudes of the public and the attitude towards crime and the criminal justice system, especially towards crime. What we see is that the media and in many countries, the politicians or some political parties are very fond of the crime. sorry for this expression, I mean the discourse on crime has been put in the political agenda for many years now in Europe. And if crime has a position in the political agenda, then the response to the crime or the attitude, how to tackle crime, much needed for the political identity of the party. So what we see is that we have then the zero tolerance policies. Of course, zero tolerance to any form of violence is a value, is the aim. We can't, however, demand from the from the societies which are based in the conflict, not in the concept. Most societies are based in the conflict and how to resolve the conflict. So it's a utopia to have peaceful societies without crime. In this theoretical construction, the responses to crime are punitive. And this kind of punitiveness is the key issue in the political discourse expressed by some parties to not really to handle the crime, but to develop a very radical right-left but radical political discourse on crime. This is penal populism, when you use the crime issue to make your politics or micro-politics.
Okay, quite clear about it. We have another question related to the changes in our legislation, EU legislation, but in every country, member states. Generally speaking, all the threshold of penal punishability was lowered by the new regulation and legislation, and therefore in some way radical behaviors once not considered offenses or crimes, now they are. Therefore, the question is, well, the consequence of this modification introduced by the EU and the United Nations, the consequence is that we have now hundreds of young guys in prison with short convictions, and but the hard condition of the penal execution, and this is the question, don't we risk to create terrorists and violence recidivists with this unbalanced policy?
What is the question?
The question is, well, with the introduction of new offenses related to more to can we say to radicalization than specific terrorist acts and crimes, and the conviction of hundreds of young guys for their for these new offenses introduced in the legal systems of the national of the EU member states, and at the same time the application of hard condition of penal execution in the penitentiary system can be a source of radicalism to worsen the situation instead of finding. It's not a solution. The question is, this is it can be not the solution, but can put in danger, more danger, the society.
The question for me,
Yeah.
the answer for me. Okay. So there are a few points here. The first point is that actually we see the last years a trend in using the term radicalization, and we all know that the term is very, very problematic. So if in the second stage we try to implement policies on a term, the crime that is so vague, so that means that everything is not so clear at the end of the day. If in the third stage we go on the prisons and the correction system, we know that this the penitentiary is less effective in rehabilitation for many crimes. If I could say for all crimes, I mean that what we see is that for criminals out of the society for a certain time as their conviction. So in terms of radicalization, we have to be very, very skeptical, and we have to be very careful when we have certain policies, legislation on an issue that is in between. It is true. We can't deny that there isn't radicalization, but we have to define it, and we have to be concrete. From my point of view, if you are only convicted in a prison without any other support measures, then the way is the reoffending. And we have much research on that, because the doors of the prisons are very often like the doors of the hotel. It's the same door that the prisoners enter the prison, go out in the society, and it's the same door that go again and again in the prison. So we have unresolved issues, and the reoffending in such cases is much higher. What we need here is support, clear definitions, clear legislation, conditions and standards, and support measures for different levels.
Thanks a lot. Well, do you want to say something else, Luke?
No, I think I do share most of these comments. I think we need something to be precise, detailed, adapted, and also to be balanced. Maybe some European initiative to support state policies. I think the EU has been quite efficient during the last decade to organize cooperation, and you can of course testify of this with the new regulation, the new technical instruments, but the body of proof, the sentences itself are not enough. We are to enlarge the focus to take any aspect into consideration.
Well, thanks a lot. There are no other questions, and so I pass the floor to Ms. Fagiano.
Thank you very much, Dr. Franz, and I appreciate all the contributes you speakers and moderator gave to this webinar. So I would like to thank you a lot, and I would like to thank the partners that were involved in this project. We made this project big, I guess, as you already said in the previous presently. So thank you a lot, everybody, and I hope to meet you again online or in person. Thank you. Bye-bye.